Welcome to Conozca sus Derechos, or Know Your Rights. This program is brought to you by the Hispanic Bar Association of Central Florida. It is our mission to inform our community of important legal topics affecting us all, and today we will be continuing our discussion regarding family legal matters. I am Henry Lim, the Community Relations Chair of the Hispanic Bar Association of Central Florida. Today, we will discuss various topics relating to family law. We will be discussing common mistakes and misconceptions surrounding these issues and provide information on where to go for help. During our program, we will hear from various attorneys in our community who are quite knowledgeable in the area of family law. Let's begin by introducing attorney Maribeth Gonzalez. Maribeth, how are you today?
Great.
Tell us a little bit about yourself.
Well, I have my law firm, the Law Office of Maribeth Gonzalez in downtown Orlando, and I service Seminole, Orange, and Osceola. And I practice primarily family law and criminal law. A little bit about my background. Before I became an attorney, I was a probation officer, and I helped bring the GPS units that now exist everywhere in the state.
That was you?
Yes, I helped with a pilot program. It was me, myself, and I, and the units.
Great, fantastic. Well, thank you for being on the program today, Maribeth. Also with us is Gisela Den Laurent. Gisela, how are you today?
Very well, thank you, Henry.
Tell us a little bit about yourself.
Well, I own the Laurent Law Firm, and it's in Orange County in Metro West. My practice area, the areas of practice are Orange, Osceola, Seminole, and Volusia as well. My firm specializes in family law, criminal defense, and immigration. A little bit about myself. I pretty much grew up here in Orlando since I was 2 years old. I went to University of Florida for undergraduate and law school, and then I came back to my hometown to practice.
Great. Well, thank you again for being here today. And we're talking about family law issues, and one of the main things that we see is that family law can be quite a drain psychologically on everyone involved. So where can someone go for help when they're dealing with marital issues? What would be the first place that you would advise someone who is perhaps thinking about getting separated? What's the first thing that they should do?
Well, I would say speak to an attorney. Family law is state law, so unlike immigration, which is federal law, every state has a different set of rules. So you might be given the wrong information. So even if you have to pay for a consultation or if it's a free consultation, I would speak to a family law attorney. And that's another thing. Make sure that the attorney that you speak to, it deals with family law matters.
Great, that's great advice. One of the things that we see a lot when we're talking about family law, there seems to be a perception that mothers have more rights than fathers when it comes to custody. Can you tell us a little bit about that, Gisela?
Well, you know, historically that was true. And in Florida, we started out with the tender years doctrine, which was pretty much about 30 years ago, that the courts felt that the mother was more equipped to take care of the child. Historically, the fathers worked, the mothers stayed at home and were the primary caregivers. The primary caregiver and tender years doctrine, those languages don't even exist in Florida anymore. There was a modernization of family law, and women started going back into the workforce, and but they still were the primary caregiver. So what you would see in the 80s and the 90s was that the fathers had visitation rights. And so the mother would, unless the mother was some unfit mom, most of the time she got primary custody, the father got secondary custody, and he got visitation rights, which was normally every other weekend. I think that there was a huge push by the fathers in Florida to say, we want equal rights. Just because we're the dads doesn't make us any less important than the mothers. And the courts have listened to that. And we had the change in law, which abolished the word custody. So there would be less fighting. There's shared parental responsibility is, for the most part, the norm. And there's a parenting plan. And fathers have equal rights as far as what they can ask for in family law. They could ask for equal time sharing and parenting plan. There's no presumption for it or against it. So you just put on your case and you have a good chance, if you have all the factors that you're trying to act in the best interest of my child, that you could get equal time sharing.
Okay, so what factors does the court consider when they're trying to determine who gets what amount of visitation rights?
Well, they'll look at the involvement of the parents. They'll look at who knows the teacher's name, do you know who your kid's best friend is, who takes care of the medical and doctor appointments. they'll look at the relationship, who tries to interfere with the other parent's rights, because you're supposed to, both parents are supposed to foster a relationship. So there's a list of statutory factors that you would have to litigate if one wants substantial time sharing. Now what they have is, before they used to use the word primary residential custody, and that was confusing. So now in a parenting plan, like Gisela said, they will word it differently. What they'll do is, you can't just take your kid and enroll them in any school. Okay, so that wasn't the policy behind, that wasn't what the intention of the law. So what happens is, you get a designated residential area, either the mother or the father's. But do you see how that has nothing to do with the time sharing and parental rights? You still have to go through the best interest of the child. And like I said, it's a set of statutory factors. You can agree on something at mediation, like in the Ninth Circuit, mediation is mandatory, or you would have to litigate those statutory factors.
And Henry, on that same note, the court likes to just try to get a picture of what the family was like before the divorce. So if before the divorce, both parents worked and they took turns picking up the children from school, they took turns taking the children to activities, the court's going to say, why should we deviate from that just because you decided to get divorced? And so they'll try to designate a parenting plan that incorporates what you were doing before the divorce.
Okay, well, let's say then that the court's order that I have to pay $1,000 child support every month. What, am I entitled to more visitation rights now that I'm the one who's paying for child support?
No, child support is calculated with the incomes of the parties, any medical expenses, and any time sharing. And if there's any daycare expenses. That's what, with regards to sometimes parent allowing or not allowing to see the child because of payment or not lack of payment for child support, that's not the case. Child support is a different issue. It goes with regards to those set of standards. Actually, the court doesn't consider what your other monthly expenses are. That is considered, and that's a little bit confusing to people because you hear these stories, oh, well, they put me in jail, or they told me to sell the car. That's if you don't follow what was established. So the original establishment of child support is income of the parties, medical expenses, daycare, and time sharing. That's how child support is initially calculated. And there's a deviation, 5% deviation. For example, if you have a child that has autism, that you need extra medical expenses, then you would plead for that and get a deviation from child support.
Well, talking about that, let's say that I just found out that I have a child, okay? We're talking about paternity issues here. The child's 8 years old now, and I just found out through a DNA test that the child is mine. Do I now have to go back and pay child support for those 8 years?
No. If they start a paternity action, normally it would be the Department of Revenue. That's how you were found. And so you were found, you took a DNA test, and they will go back 24 months. That's what the law allows. Many people say, hey, why should I have to pay? I didn't even know the child was mine. But the court sees the child still needed to eat, still needed to be supportive, and if the Department of Revenue found you, more likely than not, the mother was receiving some type of financial assistance, and the state needs to be repaid.
Well, what happens if I can't pay back 24 months worth of child support? Can my bank account be garnished?
Absolutely. If you have funds in a bank account, that means that you do have the ability to pay. However, Florida, they're very reasonable. If they go and determine that you owe 24 months of back child support, let's say it's $14,000, they're not going to make you pay it all at once. They'll order a repayment, and it could be $50 a month towards the arrears plus the ongoing child support obligation.
Great, great. Now, what about my bank accounts? You mentioned the bank accounts, so can they be frozen? Does the state have the right to freeze bank accounts based on child support?
Yes, they can freeze your bank accounts. They can intercept tax refunds. You may not be able to get a passport until you pay the child support. So there's different methods.
Okay. Well, let me give you a different scenario. Let's say that I'm dating a married woman, and she ends up pregnant with my child. Do I have any legal rights over that child?
No, actually, a child born in a marriage, You are the biological father, and the husband of the woman you're seeing is the legal father of that child.
So as a biological father, do I have any rights?
You really don't. You know, it's going to all depend on the legal father. If the husband, you know, and this happens all the time, it's just so
Yes.
funny. If the husband is infertile and he found out that his wife was cheating on him and got pregnant, he may say, you know what, I don't care. Let's raise this child together. The minute he says that, the parties, you know, the privacy of the home is a constitutional right, and there will be nobody who could break that veil. And so you as biological dad will have no powers against this legal marriage. The sanctity of the marriage is what they call it. And so you're out of luck.
And it can happen. No, it happens a lot. And it could be the other way. You're getting a divorce, the husband, not you. The husband's getting a divorce. Well, now you're the legal father who pays for child support. It's actually not the biological father. It falls on the legal father.
Fascinating. This is completely fascinating.
Yeah.
It's time for a short break. Please stay tuned as we discuss other topics in family legal matters. Welcome back to Conozca sus derechos, Know Your Rights. Programming brought to you by the Hispanic Bar Association of Central Florida. I am Henry Lim, Community Relations Chair of the Hispanic Bar Association of Central Florida. We're continuing our discussion on family legal matters with attorneys Maribeth Gonzalez and Gisela Den Laurent. One of the topics that we see a lot is domestic violence. What is the first thing someone should do if they feel they are victims of domestic violence?
Well, Henry, I think the first thing that they really need to do is contact law enforcement so it's documented. Even if the police show up and just keep the peace and have one person leave the home, at least it's documented so that if there's a history of violence, you have that documentation.
And is there a difference when it comes to domestic violence between a civil matter and a criminal matter?
Yes, usually domestic violence can go along with a battery charge. So, for example, for a battery for a battery charge in the criminal court, there's a higher burden to prove. It's beyond to exclusion of every reasonable doubt. So you might lose on a criminal case, but you might win on a civil case because it's a lower standard. And also, who is the client? And so in the criminal matter, the state is against the person that committed the crime. In a civil matter, it's the victim. It's the victim that gets to speak out. So, for example, in a civil matter, it's the victim that is the case. In a criminal matter, even if the victim doesn't want to testify, and this is usually what's confusing because they'll say, I don't want to move forward with the case, the state can still proceed in a criminal matter. And also, if the person that's being accused, if you did it, you might not want to say anything in a civil matter because whatever happens in the civil matter and the domestic violence injunction can be used against you in the criminal law matter, which makes it a lot more easier and faster to prosecute you in.
Well, let's talk about something that you just mentioned. You mentioned that even if the alleged victim does not want to pursue criminal charges against the perpetrator, the state can still charge the abuser.
Yes.
We see a lot of programs on TV. We see that, oh, you want to file charges, and when they say no, that's it, they're done. So how does that work?
Well, they'll still need to prove their case. The state has to meet its burden. So if the victim is uncooperative, they're not going to be able to meet their burden. However, the state attorney's office has a victim advocate that will talk to them. Maybe the victim is scared and says they don't want to prosecute, and they really do, because maybe they have lack of resources or don't know about Harbor House. So even if they say they don't want to prosecute, the state will still move forward. Technically, they can sanction you, but they're not going to do that.
They don't try to re-victimize the victim. But as Maribeth was saying, they can still go forward. And what happens is that domestic violence doesn't always happen in a bubble. So they can have independent witnesses. If this happened in a parking lot or an apartment complex and they have independent witnesses, they will go forward. And if there's a history of domestic violence, there was children involved, they'll have other motivating factors to take the case forward without the victim's cooperation.
So let's say that someone calls the police and it's the fifth time that the police has been called to the house. Those other times can be used against the alleged abuser?
They won't be used against the alleged abuser. However, it will be more motivation for the state to go forward on the case, because you can't use prior bad acts against a person in the current charge.
And we're talking if the alleged victim does not want to pursue charges, even though she's called the cops 5 times.
Exactly. She has called the law enforcement 5 times. The state finds out about that. They're going to say there's more to the story, and they'll be more motivated to go forward.
I see.
But actually, and just because that actually happens more than not, and sometimes the reasonable person looks unreasonable. So there's cases where the victim calls multiple times and then drops the charges, and then it's like crying wolf. They don't believe you. Even though it's happening, they might not take the victim serious because she keeps dropping the charges. So that's a little difficult situation to deal with.
Okay, I see. Well, we've discussed civil and criminal, but perhaps we should clarify a little bit. Criminal is when the state is pursuing criminal charges against an alleged abuser, correct?
Yes.
And civilly, what does it mean when you're talking about civil relief available to an alleged victim? What can a victim do with using the courts on a civil side?
Well, on the civil side, the victim can ask for a petition for a domestic violence injunction. What that does is that takes some measures. For example, the batterer might be told to stay away from the victim 500 feet within the house. Also, to any places that she visits currently, I'm sorry. Also, the injunction will put in order child support, time sharing for that period of time. However, if those issues are so severe and there's a marriage, you should also seek a divorce, because the injunction ends at some time if it's not permanent. So it's not forever. Sometimes they're granted for 3 months, 6 months, a year. So you got to be careful with regards to that.
Can an injunction ever become permanent?
Definitely.
And what does it mean when we say permanent? Does that mean forever, that the person cannot contact this individual?
Yes. Like Maribeth said, initially an injunction, well, first of all, when you apply for an injunction, if there's grounds, the court will give you a temporary injunction and have a return date so that the other party can defend themselves against this injunction. At that hearing, the return hearing, the court can decide whether they're going to give it for a month, 2 months, or indefinite, which is permanent. The reason for an expiration date is if there's something going on within the relationship, for example, the parties are about to go through divorce, the court may find that because of this divorce, this aggravating factor, they just need a Band-Aid to get through this process, and then the hope is that they'll have a transition period and they'll move on with their life. The injunction, if you don't come back within the time that it's actually open, it will just automatically close, okay?
Now, what does one have to do in order to have an injunction approved? What do you have to prove? What's the standard of proof for the alleged victim to have an injunction approved by the judges?
It's the standard is imminent fear of harm. So,
and how is that defined?
Well, if the party has a reasonable fear that they are in danger by the other person, first of all, they have to be domestic, so because there's a repeat violence is a non-domestic. But if it's domestic, so you guys are related by blood or marriage, or you've lived together, and then you're in imminent fear of harm, that means you reasonably believe that this person will harm you. That's it. It's a much lower standard to prove. If the court believes that you're in fear, they will grant your injunction.
And the biggest mistake that people do with regards to imminent fear, because there is no straight answer. So, for example, if something happened 2 weeks ago, and now you're going to seek an injunction about something that happened 2 weeks ago, that's not imminent fear.
I see. Okay. Well, let me give you an example. Let's say that my ex-wife files an injunction against me, okay? Or my wife, and we haven't gone through proceedings, files an injunction against me. The judge grants the injunction against me, okay? And she calls me and she tells me, "Hey, come on over. Let's get together for lunch." And I show up, and for lunch, can I be arrested? Am I in trouble?
Yes, it could be a first-degree misdemeanor, a violation of injunction. You can be charged with that. But yes, because there's no injunction against her. There's no order restricting her, telling her what to do. The person that has the order is you. So you are disobeying an order from the court.
Do I have any defenses?
Absolutely not. It might be mitigation because the court ultimately has the discretion to what his sentence is going to be for your contempt. And you can say, listen, she contacted me, she said that she had talked about the children, I met up with her, and she called the cops. But ultimately, you have to tell people all the time, you are the only one that's bound by this order if the injunction is against you.
Does injunction have anything to do, or does it affect child support? Does it affect alimony? How does an injunction come into play with those issues in a divorce setting? Because we're talking about two separate things, right? Mm-hmm. An injunction for domestic violence is different from a divorce setting. So how does someone who has been granted a temporary injunction, how can that be used in a divorce setting? Or can it?
Well, it can be used different ways. First of all, in a domestic violence injunction, they can put temporary child support, alimony, settle issues with regards to time sharing, and things such as that nature. However, the divorce case will trump those issues if those issues are addressed with regards to the divorce.
Okay.
And also, Henry, at least every county is different, but what I've seen mostly in Orange County is that if the courts know you have a pending dissolution of marriage, they try to not weave them together. They will say, I'm going to issue the order for injunction, and I'm going to let the dissolution judge or court handle those issues. It makes it cleaner that way, so you don't have competing orders.
And what can I do if I have an injunction against someone and they violate it? What should I do? If they came to visit me and I tell them, no, you have to go away, what rights do I have for someone who has violated the injunction?
You call law enforcement right away. And injunctions are a piece of paper. So you've heard horror stories, especially within this year or last year within Orange County and in Seminole. The injunction does help because you can call law enforcement, and the person violates, they can be charged with criminal charges. But at the end of the day, it's very important for a victim to have a safety plan, to have a plan for where they're faced with that situation and they can't think. It should be second nature. This is what I'm going to do without thinking because this is what's happening. Because when you get caught off guard, it might be very dangerous, and the police are not right there. Right. At every moment of your life.
Right. It's very important to know your rights. Unfortunately, our time is up. We thank you for tuning in. I want to thank Maribeth Gonzalez and Gisela Den Laurent for their participation in Conozca Sus Derechos. The Hispanic Bar Association of Central Florida is dedicated to community service, and in our upcoming episodes, we will continue to discuss family legal matters and other issues important to the community at large. We wish to thank Orange TV for their assistance in bringing you this program. For further information, please visit hbacf.com. Thanks for watching. We'll see you next time on Conozca Sus Derechos.